and former Deputy AG. He's joined us on the line. Doc, you're welcome to Eyewitness News.
Thank you very much, Umaru.
So what should be the relationship between an Attorney General, and let's just use prosecutor in this case because the Attorney General is a prosecutor in this case, and a person who is standing trial? Should there not be any conversation between the two of them whatsoever? Is that what the NDC is saying? And is that what happens in practice? You have been in the courtrooms.
Well, okay. So as a matter of law and the ethics of the legal profession, the Attorney General as the prosecutor is not, it's not by law permitted, okay, to speak to an accused person without the presence of the lawyer of the accused person. And then this is, in the context of a criminal prosecution, we must understand that the accused person is very vulnerable because the liberty of the accused person is at stake. In some cases, it is the life of the accused person that is at stake. And so, for an Attorney General who is vested with prosecutorial powers, to speak to an accused person in respect of matters pending, that affect the liberty potentially of the accused person is unethical, and it is also illegal. So, for instance, if you look at our legal profession rules that have been cited severally by, the National Communications Officer of the NDC, Sami JP, Rule 56 is very, very clear. 56.2 is to the, 56 rule, sub-rule 2D is to the effect that the prosecutor has a duty not to confer with an accused person or interview the accused person. Now, I had the occasion, to listen to the entire tape that was played during the NDC conference that was addressed by the national chairman. And in that tape, it was very, very clear that the Honorable Attorney General, the Attorney General was actually conferring and in some instances actually interviewing the accused person. That is illegal. That is unethical. And as the Honorable National Chairman of the NDC has said, he has brought the Office of the Attorney General into disrepute. But Umaru, there are a number of dimensions of this, matter that have not been touched upon in the public discourse. One is the fact that the power to prosecute is discretionary. And in any situation where discretionary power has been vested either under the Constitution or by statute or any rule in any person or authority, that discretionary power is subject to the principles in Article 296 of the Constitution. All right? So you cannot exercise the power in a capricious manner or in a manner that is biased by resentment or personal dislike. When I listen to the tape, the tape tells me is that it is providing ex post facto evidence of the Attorney General's personal dislike for the Honorable Minority Leader. Because basically what he was, doing in that case was trying to drive an accused person who is himself a witness, and that is the point about the vulnerability of the accused person, because the man is taking the stand and the oath in defense of himself and seeking to extricate himself, from being sent to jail. All right, and you are now pushing him to give evidence against another accused person, so that that accused person will go to jail. Because of the vulnerability of this person, what you are basically doing is taking advantage of him being opportunistic, so that at the end of the day, it is not the evidence that you have adduced in court, okay, that proves the guilt of the minority leader beyond reasonable doubt, but it will be that you are either falsifying or fabricating or seeking to push an accused person to lie in court so that the minority leader goes to jail. And that is a violation, of Article 296 of the Constitution. So the first duty, of a prosecutor, all right, and the Attorney General is the chief prosecutor of the Republic. The first duty okay, is to protect the innocent and convict the guilty. That is what you are supposed to do. You protect the innocent and convict the guilty.
So,
but in this case,
if that conversation is to be believed, can he not get further and better particulars to guide him in this prosecution? Is that wrong? To try and get information from him?
No, he cannot obtain that information from, an accused person, from a defendant in a criminal trial. He cannot get that information from a defendant.
But is he barred from having conversations with him at all? Can the AG be making phone calls to?
He's totally barred from having conversations unless the conversations are in the presence of the lawyer of the accused person.
What if the accused person didn't have a lawyer at that time?
That is a fantastic question. So if the accused person is unrepresented or does not have a lawyer at the time that the prosecution is seeking to communicate with him, then it must be done in the presence of the judge. That is the practice and convention that we are all used to. And I can assure you that when we were in the AG's department, neither myself or the Honorable, Marietta, Brew, okay, would have taken this step, to talk to an accused person, without their lawyer or not in the presence of the judge.
Now that you've mentioned the presence of a judge, it has to be the judge in the case being trialed, not any judge like we are hearing now, where there's a judge of the Supreme Court, we are told, whose resident hosted this meeting.
I'm talking about the judge, okay, in this matter. Because you see, Umaru, if there are orders that have been made by the judge, and the Attorney General thinks that those orders must be complied with in a certain way, and the accused person is not, represented by a lawyer, the only way by which that accused person can, understand why the Attorney General is seeking, to have those orders complied with in a certain way, is for him to appear before the judge, either in chambers or in open court, for directions to be given, and for the accused person to also make his input in the presence of the judge, for the judge either to vary those orders or to say that she's taken by the orders that were originally made. I'm just giving you an example of a situation where, the Attorney General ought to bring the matter before the judge so that the accused person is protected, from being taken advantage of.
Now that the NDC has promised to prosecute Godfrey Dame, what would be the basis for possible prosecution in relation to this audio? Because the MPP has said to us that there's nothing in there, it's just an empty tape. What would be the basis? So the charge would be for conferring with a person who is accused. What possible charges can be brought against Godfrey Dame, and why must he be fired by the president? Why must he?
Well, I would not want to. I would not want to comment on possible charges, because I wouldn't want in any manner to prejudice anything that will be done in the future. However, it was mentioned at the press conference, okay, that there's a possible criminal breach of the sections of the Criminal and Other Offences Act, or dealing with the falsification of evidence, the fabrication of evidence. Specifically, I think it's, sections 213 and 214. And I think that the tape, okay, this is my initial opinion, the tape provides potential basis for further investigations, in order to bring a prosecution under those particular sections.
Thank you so much for speaking to us, sir.
Thank you.
That's Dr. Dominic Ayine. He's a former Deputy Attorney General.